but the way I imagine it is that you have a bunch of firms that sell the service of protecting their customers' rights and settling their customers' disputes. You then have every pair of such firms whose customers might get into a dispute need some peaceful way of settling it, because shooting at each other makes it very hard to hire employees. And also, your customers don't really want their front lawn turned into a free fire zone. So therefore, it pays each pair of firms to agree in advance on an arbitrator. Uh, that agreement is enforced by the fact they're repeat players, that each of them knows that if when its customer loses the case, they don't go along, then the next time the other one won't go along and they're back shooting at each other, and now they lose customers to more sensible firms. That's the basic logic of it. And then part of what's interesting about it is that you then have a market mechanism for generating law. Now, to some extent, that already exists. If you think about private arbitration, there is private arbitration, mostly among firms. The arbitrators implicitly have a legal system. They've got some set of rules they're going by, and presumably they are trying to design their rules to be ones that customers will want to be under. But in my system, that's the whole legal system. That basically each each arbitration agency works out those rules that it thinks will result in rights enforcement agencies choosing to use its services. Rights enforcement agencies want to use the services of arbitrators who their customers will want to be under. So there's a market pressure for legal rules that don't result in large costs or much uncertainty, or results people don't think are fair, and so forth. So you're then having it generated by a market mechanism. That's the basic logic of it.